Now, the million-dollar question now is, what forms part of the estate of the deceased person? Does any property form part of the estate of the deceased person? The answer is no. No. What does this mean? It means that even in the will, the deceased person or the testator can only dispose of or only include the property that belonged to them. And how do we prove that such property belonged to this particular deceased person? One, if it is land, if it's titled land, can we produce a land title in the names of the deceased? If there are shares in a given company, can we produce a share certificate to that effect? Because actually these ones have to be annexures to the will. If you refer to a given piece of land, can you attach that particular title? Or can you attach that particular land or purchase agreement? If there are shares, can you attach your share certificate? Right? If you're in a given partnership and you say you have you have such shares in that particular partnership, can you attach the partnership deed speaking to that, speaking to such a share in that partnership? Are we together? If you're speaking about maybe money saved in the bank, do you have an account? Can you prove that that account indeed belongs to the deceased person? Now, what forms part of the property of the deceased? Any property that you can prove that indeed it belongs to the deceased person. It can be movable or immovable. If it is a car, you have the logbook in the names of the deceased person. If it is a leasehold, you have that particular, any document speaking to that lease. Right? Because at the end of the day, all we want is to make sure that the will only contains property that belongs to the deceased, and he has duly disposed of the same in that particular will. Less that, a will cannot dispose of property that does not belong to the deceased person. Key concept, we have said, property can be movable or immovable. Bakama bange kitutegeeza wano nti ebintu byokka by'oyinza okuteeka mu kiraamo kyo ng'obigaba eri abaana bo n'abo b'oyagala byebyo by'osobola okukakasa nti bibyo. We liba ttaka olina ekyapa nga kiri mu mannya go era wakyataakinga ku kiraamo kyo. Weba mmotoka olina logbook eyo eri mu mannya go. Bwe gibanga migabo mu kampani olina certificate eraga nti olina emigabo egyo gigyo. Bwebanga partnership olina kyosobola okutunuulira oba okusongako n'ogamba nti mu partnership eno ninamu emigabo bwe giti. Bwebanga business nga joint business olina ekiwandiiko kyonna ekiraga nti business eno olinamu emigabo. Bakama bange, obanga ekyo tekiriwo tetusobola kugamba nti ekintu ekyo kikyo era osobola okukigaka mu kiraamo kyo. Akasembayo tulina concept gye tuyita joint property, or what we refer as joint property or joint ownership of property. Mainly this works in land or in land matters, where we can have 4 people registered on the same piece of land as joint owners. And oftentimes at the end they can put a word known as no survivorship, or they don't put. It will mean that if they don't put it, they have decided that the concept of survivorship does what? Happens. Now, when you find a land title where you have 2 people, one is dead, but the land title specifically puts up a word no survivorship, it means that once one of the owners dies, a share of that deceased owner will now belong to their estate and can be claimed by their what? By their children. Now, in instances that they have not put out the word no survivorship, and these 2 people are joint owners of this particular titled land, once one dies, the property now will solely belong to the surviving proprietor. So that land will not form part of the estate of the deceased. In another detailed video in land law, we shall speak about ownership of land. That will be for another day. And still, we shall make more detailed videos on tested succession and intestate succession. Today, we have not delved into issues to do with intestate succession and how the law dictates how property has to be distributed when it comes to intestate succession. That will be for another day. And the million-dollar question there would be, how does the law cater for a person who has died recklessly without providing a will or without providing for any estate management tool for their property? We shall see what does the law dictate as a share to the spouse, what does the law dictate as a share to the lineal descendants, what does the law dictate as a share to the dependents, and who are entitled actually. We shall have another video on letters of administration and on grant of profit. But for today, allow me to end here after explaining to the layman what estate planning means, the advantages of estate planning, and the different estate planning strategies. If you have any question, please don't hesitate. Pin it down in our comments. We shall answer the same. And if you feel you want a personal interaction with us, don't as well hesitate. Just make a call. We shall answer and set an interview or set up a meeting, and then we shall handle the same. Otherwise, I remain Fred Magala. Thank you very much.